Let's go to Parliament and to the courts.
When voters elect a candidate, they do so based not only on the individual's personal qualities, but also on the political party platform they represent. Party switching or defection, therefore, can be seen as a breach of the mandate and social contract between the Member of Parliament and the electorate. These constitutional safeguards ensure that members of Parliament remain accountable to both their parties and the electorate.
Alban Bagbin then proceeded to thrash argument that the constitutional provisions in question only applies to the future.
If Article 97(1)(g) and H were to apply only in future parliaments, it will render these provisions effectively superfluous. By the time the next parliament is constituted, any member of parliament who has defected or switched political allegiance during the current parliament will no longer be in violation of the provision. Accordingly, I proceed to inform the House that by the notification of the polls, the following members of Parliament have by their actions vacated their seats in Parliament.
With respect, for the past 12 years, I have accorded you every respect, and I'll continue to do that. Mr. Speaker, the facts you put out are not true. Mr. Speaker, these are credibility issues, so I will respond for the record. Mr. Speaker, somebody has told you something. Mr. Speaker, you reserve the right to be there to make your point. Let me make my point too. Mr. Speaker, no way. Mr. Speaker, no way. Mr. Speaker, whoever told you, Mr. Speaker, whoever told you that I threw a paper at somebody, this has to do with my credibility. I will not allow hands.
No, honorable member, you don't listen at all.
Mr. Speaker, I do.
I never said
Mr.
you.
Speaker, you said
I never said you threw a paper at anybody.
Mr. Speaker,
I never
Mr.
said
Speaker,
that.
that's exactly what you said. Let the answer check it.
You
Mr.
see,
Speaker, that is what you said.
You are being carried away by your
Mr.
anger.
Speaker,
You are not listening.
Mr. Speaker, I'm not angry.
Honorable member. Honorable member.
Mr. Speaker, I'm not angry.
I said the court process was thrown on the table in the office. I never stated it was thrown by you at any person.
Mr. Speaker, you said I allegedly said some bailiffs. Alleged bailiffs.
No.
Mr. Speaker, then clarify.
Please.
Mr. Speaker, with
listen
respect,
to me.
Mr. Speaker, I'm listening.
Honorable Majority Leader, I don't want to proceed to make some orders. Please, resume your seat. I'm very serious about that.
Mr. Speaker.
Please, resume your seat. Honorable member, your
Well, this is MPP. The founders of our tradition use the courts to do full right. And true to it, we are Democrats. We don't believe in violence. We don't believe in mischief and unnecessary political chaos. We came to court believing that the court will do right. And indeed, the court has just done that. The rights of those MPs have been reinforced, as well as the rights of those constituents who elected them. I will leave the Ghanaian public to peruse the full ruling of the court, and then the discussions can continue. But let me thank my colleagues in leadership, especially the hardworking Majority Chief Whip, for all the support and his industry. I thank senior members of Parliament, Uncle Joe Gatti, Honorable Kennedy Japan, not the least Uncle Katie Hammond,
This is the Speaker's information to the House. So how do you say such an information?
But the Speaker was called to rule on a concern the minority leader had brought. Isn't that the case?
Are you the one calling it a ruling? Are you the one calling it a ruling?
But what is it?
The person who spoke to the House says this is the information I have for you. So if you are labeling it as a ruling, I don't know how that can be so labeled. He says this is the information I have, that these 4 members of Parliament have, by their conduct, done A, B, C, D. The Speaker has given information to the House. Then somebody goes to the court and says that this amounts to a certain order, and therefore that order should be stayed. How is this to be stayed? With all due respect to the court.
This current Supreme Court is too predictable. And yesterday, I emphasized the point that the NPP may rush to court to get a verdict, with which they can dance around the present Supreme Court and back to Parliament. That's exactly what. But be that as it may, I am going to urge the general citizenry to just be respectful. Having said that, I'll add that I'm not surprised, because if you look at the composition of the Supreme Court that sat on the case today, they were all appointed by the current government. And I spoke against it. It was as if they were packing the court for instances that have happened today.
Why? Are you saying they've done?
Right. So you heard the Speaker of Parliament, Aban Bagbing. You heard Afenyo Marking. The two of them had a little banter there because he's alleged to have filed a suit. He had filed a suit, and he's alleged to have brought the suit in Parliament with the bailiffs. And the Speaker said he threw it at the people. And he tried to speak back at the Speaker to say, I didn't throw it. And the Speaker said, you are not listening. I didn't say you didn't throw it. At that moment when they were having the argument, I did a quick review, and I heard the Speaker say, you threw it. So Afenyo was right about that at that point. Except I'm asking, how do you serve a process whilst the Parliament is sitting in the light of Article 117 and 8? Well, let's see how all of that pans out. Then Roxanne and my colleague also here have a debate about whether it was a ruling or it was not a ruling. What does that change, really? Okay, so let's begin right here from the studio. And so, Dominic, it's been said that the Supreme Court, by what it has done, clearly points to the Speaker having done something that is so wrong, particularly in not giving a hearing to the affected MPs. And the court said they should not be deprived of representing their constituents between now and when, Parliament ends its work. They should not be deprived.
Okay. Thank you very much. I had the occasion to review the ruling of the Supreme Court, and I was really very surprised that the Supreme Court took very seriously the issue of breach of natural rights. I mean, the right of the persons affected to be heard in their defense. Something. First of all, there was nothing to defend, in the sense that they had committed acts which, in the public domain, were tantamount, to a breach of Article 97. In other words, their conduct brought them squarely within Article 97. And the Speaker was merely invited, by the Honorable Atuforsen, to take account of these developments, all right, and to say whether and the extent to which they had breached Article 97, or they could be brought within Article 97. because in the view of the Honorable Majority Leader, okay, there had been the occurrence of a vacancy. And that is what he brought to the attention of the Speaker. So Mr. Speaker invited comments from the House. And after the commentary by, the members, including members from the MPP side of the House, Mr. Speaker then decided to respond to the comments or to respond to the statement by the Honorable Atuforsen. And it was his response that formed the basis of the so-called suit. Okay, but let's go back to the history of this development. You will recall that I think it was on the 15th of October at a rally in Tamale that the Honorable Member for Tamale South, the Honorable Harun Edrusu, made the point that there may be, vacancies in Parliament when we resume. And he was basically referring to these developments. So when we resumed, I think was it on the 18th? 15th. We resumed on the 15th. Okay, so when did he...
Yeah, so he made a comment, I think sometime on the 13th.
On the 13th, not on the... Yeah, on the 13th.
No, I think when we resumed, the comment was made on the same 15th.
No.
The Speaker said...
No, making it outside of Parliament.
Outside of Parliament. Yeah. Okay, so let's even say, I got the date wrong, but he made these comments in Tamale regarding the occurrence of the vacancies. Then when we came back, we resumed in Parliament. He brought a notice of petition. Now, a notice of petition in Parliament is a notice to Mr. Speaker about, the intention or an expression of intention to bring a petition before Mr. Speaker. When that notice was brought to the attention of leadership, then the Honorable Atuforsen said, look, in the circumstances, I have prepared a statement on this matter, and I'm invoking Order 93 of the Standing Orders to be able to make this statement. When he made the statement, something, at that point, the Honorable Afenyo Markin intimated to the House and to Mr. Speaker that he had filed a suit. Okay,
on that day,
the 15th. The suit was against the Attorney General and then the Right Honorable Speaker. And that was a development that surprised a lot of us, especially we, the legal practitioners in the House. Because prior to Parliament taking any action, Afenyo Markin had already rushed to the court to issue a writ accompanied by a statement of case, saying that he was inviting the court to interpret Article 97. Now, I have not seen the papers that he filed, so I will not be able to talk about the reliefs. But when I read the ruling, one of the things that surprised me was the fact that the court took very seriously the whole idea that these persons were not given a hearing in Parliament. Okay? Because in terms of parliamentary procedure and practice, right, when debate is ensuing, when Mr. Speaker invites comments, the members who are affected are at liberty to rise on their feet and say something in their defense. Okay? The fact that they were not there on that day is of no consequence. Otherwise, debate in Parliament will be halted interminably, except to say that, okay, Mr. Speaker should have specially invited them to come and then, say something in their defense. But what were they going to say in their defense? That they have not filed, in the case of the Formina MP and the second Deputy Speaker, that he has not filed to contest, on the ticket of the New Patriotic Party. When that is a public fact, okay, verifiable from the, the Electoral Commission. In the case of the independents from our side, okay, he has filed, and we have evidence that he has filed to contest as an independent in Amenfi Central. And it is the same for the rest of them. So what were they going to say in their defense that makes it so important, so significant, that you would say that the right to natural justice was breached, and in the circumstances, the Speaker, was wrong, okay? Secondly, something. I looked at
part of the procedure that's been complained about. Professor Michael Quay says this ought to have been triggered by the affected political party and not just any member of Parliament.
There is no support for that proposition in law. If you look at 97 and the Constitution as a whole, there is no procedure except and under Article 99, and I will come to 99, in the course of my submissions. Under 99, you can trigger an action in the High Court, okay, on certain grounds, which I will talk about later. So, but if you take 97 as it stands, there is no procedure, either, in the Constitution itself or in our standing orders regarding the presentation of a petition by the, and then the whole idea that it is the political party that is affected, that has locus standi to bring, or that has the capacity to bring a suit, okay, that I think that proposition has no legal legs to stand on. So when the matter was brought to the attention of Mr. Speaker, it was within his right to invite comments. He invited comments. We all made, our input, okay, especially the lawyers in the House, including the Honorable Joe Gatti. And then Mr. Speaker decided to respond. And it is that response which is now the subject matter, of the ruling. But I was going to say that, you see, the Supreme Court in its ruling, okay, in the haste to, make its, assert its authority, okay, the court grossly erred on two accounts.
Sure, sir.
Right? On two accounts. First of all, there was an application. The subject matter of the ruling was an application for stay of execution. Something you and I know, right, that there is no executable order or ruling. For a stay of execution, an application for a stay of execution to be well-founded, first of all, there has to be, a judgment, right, an executable judgment, and ancillary orders or orders pursuant to that judgment which are about to be executed.
The famous NDK case,
NDK,
according to the Supreme Court.
And if you go back to even 1963, Joseph and Jebele, brothers, and so on. All right. So,
what does it mean? Explain to my viewers and listeners. What does it mean to say that the thing you can stay must be executable? What does it mean
so
not executable?
Okay, so it must be an order. Okay, let me give, since you want the viewers to understand, I don't want to be talking to only lawyers and law students. Okay, right. But so let's take the case of an order by the magistrate, court, right, or the rent magistrate for the eviction of a tenant because the tenant has defaulted in the payment of rent, right? The magistrate gives an order for the eviction of the tenant, and then the landlord goes with bailiffs, to get the tenant evicted. That is an example of an executable order, right? Because it is an order made from a judicial authority, okay, which has the power of law to affect rights and liabilities, okay? And therefore, when it is made and the person who is affected wants to contest the order, that person will then come to court and say, look, I want the order stayed and not executed against me so that I can proceed to challenge the judgment that was rendered against me.
Right, so that right. You guys are running away from, quote unquote, calling it a ruling or an order of the speaker, because he simply said, I'm bringing this, announcing and bringing
no,
it.
Let me
so let's say what that means is, what the speaker did, you don't need any other further steps to enforce it.
Right.
So it's not executable.
That's basically what I'm saying. But even if we were to call it a ruling, all right, it must be a ruling by a judicial body or a quasi-judicial body. Okay. All right. And so I want to, for a judicial body, I'm sure everybody understands that this is a court of competent jurisdiction. A quasi-judicial body may be an administrative tribunal.
Like Shraj.
Like Shraj, for instance. All right. Or, and this is very interesting, let's say a committee of parliament. If you look at the Constitution, committees of parliament have the powers of the High Court to enforce attendance of witnesses and then to hold people, for contempt. So if a committee of parliament, makes an order for someone to, a witness to attend upon it, and let's say the witness decides not to attend
or produce
documents, and they default in doing so, that is an order which is executable because under the Constitution, the Committee of Parliament has assumed the powers of the High Court, and the High Court is a judicial body. Okay, so Parliament as a whole, all right, as we all know, is a lawmaking body, is a legislative arm of government, all right, and matters ensuing from Parliament, if they are not acts and omissions that can be brought within the ambit of Article 2, of the Constitution for either interpretation or enforcement, all right, you cannot say that, let's say the High Court will say, Mr. Speaker or a Committee of Parliament should stay, taking a step in order for the person affected to then, vindicate his rights in court. That is an anomaly. And so the Supreme Court erred on that ground because the subject matter of the so-called stay is not a judicial order or a quasi-judicial order that can be stayed.
That's point 2.
All right. Now, when it comes to jurisdiction, again, their lordship erred. Okay? Because the Constitution is very clear.
But when there is, before you move on,
right,
when there is a judicial order, before you are able to stay that judicial order, you must have an appeal.
Yes, so you have to file a notice of appeal. All right. I didn't want to go into all those nitty-gritties because in the case of Parliament, okay, the Honorable Afenyo Markin was on his feet, and he wanted to adopt an unusual procedure to respond to Mr. Speaker. And Mr. Speaker said, no, you cannot. When the Speaker has made, rendered his ruling or response to statements from the floor, no member, can get up and rise on his feet or her feet and then either challenge Mr. Speaker. If you want to challenge Mr. Speaker, you have to come by substantive motion. But you cannot also, rise up and now comment on what Mr. Speaker has said. That is the procedure and the practice in the House. So when he wanted to challenge Mr. Speaker, Mr. Speaker told him that, he was not going to give him leave to challenge him. So there was no appeal, properly so-called. There is no notice of appeal before any, a court of competent jurisdiction for there to have been a stay, of execution. All right. Now,
in fact, and we are putting the facts out for you as far as we know them. In fact, the suit was instituted on the 15th. The Speaker's decision was taken on the 17th. Correct?
Right.
Thank you.
Now, that is also one aspect which I will come to shortly. But okay. I want to deal with the issue of jurisdiction. And the reason I'm talking about the issue of jurisdiction is because this is very important. The subject matter of the suit before the Supreme Court relates to the declaration of vacancies. All right? Because Mr. Speaker had said that vacancies had occurred in these 4 constituencies. And he was informing the House, pursuant to Order 18 of our standing orders, that vacancies had occurred. Now, let's even say that the suit that was filed prior to the response of Mr. Speaker or, the ruling of Mr. Speaker correctly identifies the act or omission of Parliament that has to be dealt with by the Supreme Court. All right. The issue that it is raising is one in relation to the declaration of vacancies. And the Constitution is very clear in Article 99B that in respect of declaration of vacancies, it is the High Court that has jurisdiction. So at best, the jurisdiction of the Supreme Court in this matter will be a reference jurisdiction in the sense that when the suit is pending before the High Court and a matter of interpretation arises from that suit, then the High Court will stay its hand and the matter can be referred to the Supreme Court for interpretation, and then the High Court will now be bound by the interpretation rendered by the Supreme Court. In this particular case, the Honorable Afenyo Markin is alleging, okay, that there are issues of interpretation, all right, given the fact that his suit was filed even before Mr. Speaker's ruling. I had said on the floor of Parliament that it was drawing the court's attention to a hypothetical situation. Okay, and you know that in Bilson and Apollo, the court was very clear. If you read Pega JSC's, judgment, the court was very clear that the Supreme Court does not deal with hypothetical situations. But it deals with actual controversies, all right? In this particular case, what was the actual controversy prior to, okay, Mr. Speaker rendering his ruling or, his response to the statement made by the Honorable Atufosin? There was no actual controversy, okay? And then also, what is there to interpret? You say that you are inviting the court to interpret Article 97G and H. Something, the language of Article 97G and H are very clear. The question is whether or not the acts, engaged in by the 4 MPs fall within the ambit of Article 97G and H. That's the sole question. And that is a question of evidence that properly belongs to the High Court under Article 99 of the Constitution. So the Supreme Court clearly erred, did not have jurisdiction in this matter.
But they have not gone into that matter yet.
No, but you see,
as it is, they have not gone into that matter
no,
yet. To determine first whether there is a matter to be interpreted, because the interpretation, as you said, will only kick in. The interpretive jurisdiction of the Supreme Court will only kick in when, in fact, these provisions, there is some ambiguity, there's some lack of clarity about them. But if read and their ordinary meanings are clear to everybody, the Supreme Court will tell everybody that there's no need to interpret them.
You see, usually when courts are dealing with these preliminary applications and so on, they tend to deal with them, in a narrow manner within the context of, let's say, the application for injunction or the application for stay of execution, as was the case here. All right, but something, you see, if you file papers, all right. If you file papers, the court is, is duty bound to look at those papers as a whole. The court may not come to a decision that is, like a judgment on the substantive merits of the case, all right? But the court is bound to look at the papers that you have filed. And if I were in their case, I would have looked at the papers. In fact, the court quoted in the ruling, they quoted the reliefs that are being sought.
Yeah.
If you quote the reliefs, the release should tell you that these are reliefs that properly belong to Article 99 and not reliefs that belong to, Article 2 of the Constitution.
Don't you find that the courts seem to agree that there are serious matters of law to be determined? Because in the ruling, they state so. And we know that in determining such applications as went before them yesterday, there are about 3 factors that the court is supposed to consider.
Right.
An important aspect of the factors is to consider whether there are the suit itself discloses, arguable, points of law.
Yes.
The court found that, yes, it does disclose arguable points of law.
Right.
The second thing the court will normally consider will be whether or not, that is whether the party has a right to be protected.
Yes.
Then the second thing they will consider will be whether or not, if they don't grant the interim measure, the process, normally is an appeal, will be rendered nugatory.
Yes.
It will be of no use in the end.
In the end, yeah.
And then they will ask the question whether there is special circumstance
meriting the grant of the...
And you find in their ruling that they state so. They said, for example, that the agency and special circumstances lie in the effect of the impugned ruling, which include 1, depriving the 4 constituencies that said MPs presently represent, then he names them,
of the
that
right,
the said
right
4 constituencies in the Ashanti region, blah, 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 regions have been deprived of their basic democratic and constitutional right of representation in parliament until the next parliament by the said ruling. They said that if this impugned order and ruling is allowed to stand, it will render the grave issues raised in the substantive action nugatory.
Well, you see, that is well said. Okay. But to be able to do so, you must first of all be right in assuming jurisdiction. Okay. Yes. So if it were the High Court saying these things, I would have no problem at all with what they have said. Okay, but I still go to the point that the Supreme Court lacks jurisdiction in this matter, despite the fact that Afenyo Makin might have cloaked his suit, in the gap of an interpretative, action or an action for interpretation of the provision, I still think, that is Article 97. Okay, I still think that.
So if you don't mind, I'd like you to hold on.
Yes.
Let me go to my other guest and return to you later. Yes, Honorable Habib.
Yes.
People are saying the ordinary Ghanaian, apart from some of your members, are shocked that not long ago you were excited about the same approach by Speaker Okwe. You didn't say this is an interpretive matter. Speaker Okwe should wait until the court has done an interpretation. Now you are insisting that Vacating has done something which is wrong. He should have waited for the court to interpret the matter before he can pronounce on it. Suddenly, some of you, your people, perhaps, I won't say what I'm going to say, now say that Speaker Okwe was wrong, so Vacating too is wrong anyway. How do they trust you?
You see, Samson, my senior colleague here, Dr. Ayine, I respect him, and sometimes when he's on his feet in Parliament, in the matter of the law, it has always been good listening to him.
Because he's been a law teacher.
Yes, but I can see today he's struggling to be able to explain. I am not a lawyer, but this is a matter as a leader of Parliament. I have the history of the whole thing and how it gets to. First and foremost, the issue and the statement delivered by the Speaker was needless, and it was wrong. Whether you call it response by the Speaker, whether you call it the ruling of the Speaker, is wrong.
It is headed response.
But it is a ruling.
Okay.
In its content is wrong. You see, the minority leader, Dr. Atu Forsen, came under Order 93. And Order 93 in any sense did not give the Speaker, or he has no authority under Order 93 to write a statement.
You are opening to it.
Yes, I will be able to what Order 93 says.
Okay.
And Order 93 says that by the indulgence of the House and the leave of the Speaker, a member may explain a matter of personal nature or make a statement on a matter of urgent public importance at the time appointed for statement under Order 67. Then 6 will say that where a member makes a statement, the Speaker, considering the comment on the statement, may direct a committee to investigate and inquire into the matter where necessary, propose a legislation.
Okay.
So Order 93 have 1 up to 8. None is inviting the Speaker to make a ruling. None is inviting the Speaker to make a comment on this issue of
why not?
Of which the comment is a ruling.
Why
saying
not?
that, you see, when you read,
you just read it. Where does it prevent the Speaker from doing what he did?
Where does it allow the Speaker to do what he did?
What should the Speaker have done?
What the Speaker is supposed to do was to refer this matter to a committee, because
that says may.
No, but when it says may, but it did not in any case says that the Speaker can come with a ruling.
No, it says may.
But I'm saying that if it says may, I understand that there is still a room to either do that or not.
Yeah.
It's discretionary. But the point is that it did not also give him the opportunity to come with a ruling, of which the ruling seeks to say that some seats are vacant. My senior tried to talk about declaration of seats vacant under Article 99, and I think it's rather 1A. It's 1A. Not
okay.
Yeah. 1A, where it says that, let me see if I have my constitution here.
Article what?
Yeah. Article 99.
I think it's B.
It's
dispute
A.
About
it's
vacancy.
1A, not 1B. It's 1A. Article 99, 1. 1 says the High Court shall have the jurisdiction to hear and determine any question whether 1, that's the A, a person has been validly elected as a member of Parliament, or a seat of a member of Parliament becomes vacant.
Yeah.
B is rather talking about a person has been validly elected as Speaker.
Yeah, what's the point?
No, he was rather saying it's A or B. So, and when he said the Supreme Court was wrong in There was no
Assuming jurisdiction.
appealing and other.
Yeah.
When you read the judgment of the Supreme Court,
The ruling of
the ruling of the Supreme Court, let me just get a copy. It states clear what they were doing. I think the where they said, Mr. Baidu, that we have an application of ex parte stay of execution on the ruling of the Speaker. So the ex parte is not about any appeal on something, but this, whether you call it ruling or respond, is already a ruling. And when that's what the
Just
Supreme
because
Court
the Supreme Court has said so,
ex parte means
without
you are
notice to
coming
the
to
other
the
party.
courts on the blind side of the other party, the affected party.
So what I'm trying to say is that the Supreme Court did not err in any way.
Okay.
There is a ruling which have an effect on the composition of Parliament, on representation of Parliament, on the fundamental right of these 4 members of Parliament.
By his discussion, he's saying that by our laws, when you have to do such a thing, it must be a ruling or an order or a judgment from a court or a quasi-judicial body. And what the Speaker did in his administrative office in issuing discipline is not a quasi-judicial body. So it cannot be subjected to a stay of execution. He says to have a stay of execution, what we understand in court normally is that one would have filed an appeal against something that is executable. And the Supreme Court says if the thing is not executable, you cannot stay its execution because there's nothing to stay. So there is no appeal. Again, what it is not executable. So what would they stay? Apart from the jurisdiction.
So you see, when you read the Speaker's statement,
right?
I think when you get to paragraph, let me just get the right paragraph where he says that.
You're still here on Newsfile. This is your most authoritative news analysis platform.
The Speaker,
in just because we want to give you the best of education here, all the sides, and then I will introduce Mame Mensah Bonsu to assist us with an understanding of the law as far as Parliament and the Supreme and the court, whether the court can interfere, and if this is an interference. They talk about interpretation that Speaker should not have attempted to do what he did because it's an interpretation issue and it is only the court that can do it. What does that mean? She'll share with us.
So in paragraph 27 of the Speaker's ruling, he said that, honorable members, it is important to point out that the Speaker is called upon by standing order of Parliament, particular order 18.
And to inform the House of the occurrence of a vacancy of the seat of a member under clause 1B to E, G, and H of Article 70,
so does the Speaker,
97 of the Constitution.
So does the Speaker have the power to declare a seat vacant? Does he? Because when you listen to my senior here, he was talking about declaring a seat vacant. It's either from the High Court or in instances. In this 8th Parliament, we've seen about 3 different by-elections that have happened or seats being declared vacant. The first instance was Kumo, when Philip Baswa, may his soul rest in peace. The House was formally informed. The Speaker, the family came and informed him before Parliament right to Electoral Commission. In the case of Asim North, there was already a decision at the High Court before the appeal traveled to the Supreme Court level. So in this case, what the Speaker did was wrong. It was needless. He doesn't have that authority declaring seats vacant by the virtue of the fact that he thinks that when they file to contest as independent members of Parliament.
Order 18 says, your own standing orders 18. Order 18 says, he can inform the House of the occurrence of a vacancy.
Yes, but he has taken the decision to make them vacant himself.
Wait.
Make them vacant himself.
He did not. When he concluded, this is what he said. Let's keep to the text. He said, the House is accordingly so informed. He didn't say declared. He said so informed.
So, Samson, what I'm saying is that the Speaker is informing us that there is vacancy by virtue of the fact that Forfeiting make a statement under Order 93, or by the virtue of the fact that the Speaker think that these members have failed to be independent members of Parliament in the 9th Parliament. You see, when I am not a lawyer, but when you look at how the Constitution is framed in Article 112, I think 5 or 6, where it says that when it's left with 3 months to election, you can't do by election. I think it's 112 or so, 1126.
Yeah.
You see, they did not, they see things like this, that 3 months to general election, by the virtue of the fact that NDC, they are just the psychiatric level of becoming majority in Parliament, so they must be able to sit down. No, I'm being honest.
What do you mean by psychiatric?
This whole thing is well planned.
No,
you don't see you are seeing the law part of it, but you don't see the political part of it. The political part of it is that from day one, when we started the 8th Parliament, from the 8th Parliament, you had even come to occupy the majority.
Please.
In the 8th Parliament.
Are you saying that we are mad?
And then Speaker had to do a ruling on the composition of the Parliament to say that. I'm being honest. I'm being honest.
He's taking objection. No, I'm taking objection to that. How can you say that we are at the psychiatric level? Are you suggesting that we are mad?
I think you can withdraw that.
No, that is unacceptable. That is unacceptable.
I think you can withdraw that.
That is unacceptable. You can't describe myself
if I cannot defend it or I cannot explain why I said so, then I will withdraw it with all due respect. But what I'm saying is that you think the first time they
please,
and they have been so desperate. Even that day, they wanted to occupy the majority seat. When even after the ruling, the Speaker was still referring to Honorable Afenyo Markins as majority leader and Forfeiting as minority leader. Go and listen to watch the video. When he finished his ruling, he was still referring to them as such. But you will now be so desperate to be majority. Majority is elected when you are getting into the Parliament. It's not by the virtue of that Speaker will sit down and then you plan and write a statement and come and throw it. Even the impulse of what you said. When Honorable Haruna Idrisu made the statement before Parliament reopened.
By the information of the vacancy. No, when you lost, by the information of the vacancy, you lost 3 seats. The NDC lost 1.
So we don't think so.
Can we do
Samson,
no.
Speaker cannot.
I'm not saying no. I'm not going there.
There was already a case in court.
Habib, wait. I just want us to do this nicely. By that ruling,
we are in agreement with it, so we don't respect it.
That's why you are in court. But I just want to ask you something. We're talking about factual situations. It happened. If it had not happened, there would not have been a court order against it. So it happened.
Yes.
So by that announcement in the House, you had 3 seats affected, correct? The NDC had 1 seat affected. What was the number of the MPP and what was the number of the NDC in the House? By the effect of that announcement.
That ruling, which we don't respect.
Go back there. Can we do?
It doesn't hold water.
Let's do this. If it doesn't hold water, you are in court.
So why we went to court to say that what he did was wrong. Even our procedure, was wrong.
But Habib,
if you could have restored
for saying that we have a psychiatric, we are at a psychiatric level. I still, take objection to it.
For my respect for you,
and because if you don't withdraw, I will reply in kind, and what I will say will not please your side.
2 wrongs do not make a right.
Seriously,
two wrongs.
To call myself and my colleagues, people with psychiatric problems.
I didn't say you have psychiatric.
You said we are at the psychiatric level. What do you mean?
I said that your desperation to becoming majority in Parliament is at a psychiatric level.
What does that mean in practical terms?
Because you are too desperate.
That we are a bunch of madmen.
And you cannot be. Because we are majority, and we continue. I said I've withdrawn it.
Please.
I said I've done that.
You are majority by 1 member.
It's still majority, even by half. It's majority. Something I have withdrawn.
Even by half.
I have made and duly apologize to you, but it was not in it.
Okay.
It was about
so let's get to the factual circumstance. The night of 17th, that was Thursday, the morning of 17th, by the effect of the Speaker's action, the NPP had the minority and the NDC had the minority, in the same way that by the effect of the declaration by Michael Quay, all right, at the time something happened. So that was the situation, was it not?
Yes, that was the situation. But
right.
You cannot. You see, Mr. Speaker, in his ruling, referred to paragraph 23, Michael Quay issue. But it is entirely different. The New Patriotic Party had petitioned the Speaker of Parliament, saying that this, our member, is going independent, and we have taken a decision that he's no more a member of our party. Then Speaker Michael Quay then write to the affected member and attach the letter that came from the party, New Patriotic Party, that he should respond. Then after that, after his response, then he made the ruling. It is entirely different from this.
It's not entirely different.
It's entirely different in the sense that one...
You say difference in procedure.
No, not in procedure, entirely. Oh. Number one, there was
nobody was this discussion difficult.
No, it's difficult because...
You will not accept factual situations.
You see, Samson, the reason being, I say it's different because one, in Michael Quay issue, there was a petition from the New Patriotic Party. In this case, there's no petition from the New Patriotic Party.
Your constitution says,
if I make my point,
your constitution says, any member who conducts himself the way a Siama did forfeits his membership. That's why your constitution use the word forfeiture.
But our constitution states that.
Forfeiture.
It says automatically forfeits.
So you hear the argument. Almost both parties. That's what you have in your constitution.
Yeah.
So must the speaker wait for a party to send a notice to him that somebody who belonged to the party and the party brought to parliament has now gone to contest as independent before the speaker will see that something has happened? And the speaker refers to the notice of poll at the Electoral Commission for all the 275 constituencies that show the status of these members.
So, Samson, the point I was making was you cannot compare Speaker Michael Quay's decision or ruling the same thing as Speaker
in terms of procedure.
In terms of procedure, because
but the facts are the same.
In his case, the New Patriotic Party petitioned him. In this case, New Patriotic Party did not petition him.
Okay.
In Michael Quay's case, he had written to the member of parliament to respond. His right to be heard.
That's the point you have made the third time.
In this one, it was not.
Okay.
And the Supreme Court also was of the same.
If that had been done, you'd have been okay with it.
And
there would have been nothing wrong.
Good.
Babin could have done what he did.
Good. And the Supreme Court,
you confirm that.
No, that's not what I'm saying. The Supreme Court also
because if you say that, that would be counter to your argument that it is only the
but the Supreme Court was also of the view that yesterday I was in court. The Supreme Court was also of the view that those members were not heard. They were not.
My question to you is that if they were written to like Okoye did, you will not have a problem with Babin's.
No, my understanding on Article 97(1) G is different, entirely in the sense that if you seek to remain in the same parliament, in the case of Wayo Seni, he was a member of parliament.
Let's stay here. Let's not go to Wayo Seni. Completely different situation. Let's stay with Esiama.
Okay.
At the time Michael Quay ruled, same situation. Correct?
Yes.
My question to you now is, was Michael Quay wrong?
Yes, he was wrong.
He was wrong?
Yes. But even though there were other procedure that he tried, the Supreme Court had mentioned that was not the case.
Why didn't you say he was wrong then?
But you haven't...
You actually attacked some of the NDC who said he was wrong at the time.
I was not in parliament then.
Okay. No, he's referring to your party.
No, but
your party supported wholeheartedly what
you actually wrote to have them.
Yes,
have the person.
You keep saying something, and then many a time you say it, even the Constitution. If there is a decision today that makes it look beautiful or good, and then moving to the future, you feel like it's wrong. You know,
hindsight.
You can actually be able to say that it is wrong.
Thank you.
So what I am saying is that the Speaker, by the virtue of the fact that the members have filed, they are not filed to be independent members of parliament in this 8th parliament. They are filed to be independent members of parliament in the 9th parliament. And when my understanding of the Constitution in Article 97(1) G is saying that if you seek to remain in this 8th parliament, like if they had filed to be in this 8th parliament, like in the case of Wayo Seni, in the same parliament, I think it was the 6th parliament or so, or fifth parliament.
It was not the sixth parliament.
It was fifth parliament or so. Then he was NDC member of parliament. He read his statement. He crossed to MPP side, seeking to remain in the same parliament. Then the by-election was done and he lost. But now we are left with less than 60.
So where in Article 97 does it say that, okay, it applies to the situation where the person cross carpets, you know, in the same parliament?
So that's why we are the right forum to interpret.
So let me do this. Let me do this last thing with you. Let me do this last thing with you and then go to. Let me do this last thing with you and go to your friends on the phone, and on Zoom. Because of what you just said, let me do this with you. Article 97(1) says a member of parliament shall means mandatory. There's no option in it. Vacate his seat in parliament. Right? G, if he leaves the party which he was a member at the time of his election to parliament. Has that happened in terms of two of your members?
No, but you haven't finished.
No. Wait. I want us to take it.
There is an order.
Gradually. No, wait.
Oh, okay.
We'll go there. Apart from Esiama, those two other members, have they left your party?
No.
They have not?
Yes. They haven't left our party.
Esiama is independent and is now joining your party, correct?
Yes.
Coming back to your party?
Yes.
The other two,
joined.
What is their situation?
They are still members of the party and they are still MPP members of the
Despite
party.
Article 3 of your own consumption.
Despite going independent. Despite going independent.
That's what I'm saying, that you pause at a point.
Wait. I'm moving on with you, just gradually.
No, but if you are moving on with me,
so I want you to understand something.
Read the G
no, hold on. I'll go beyond G. I'll go to F. Listen, have they left your party?
No.
Your party says, if you do what they have done, you have forfeited your membership automatically, correct?
And our same party can also elect not to to forgo it. If the party, like certain parts
when
of the
Alan Chermanting left, when Alan Chermanting left, all of your members who joined him, you issued a statement. Do you remember what you said? That they have all automatically
in this case, did we issue a statement?
No. That they have all automatically ceased to remain members of your party by the operation of Article 3 of your constitution, correct?
It was a decision at the National Council, of which I was at a meeting, that these members have left. And for that matter, what do we do? The National Council took the decision saying that let's write a letter officially to tell them.
So your point is that even though your constitution says once you do this, you automatically leave, it has to be followed by a writing. Otherwise, the person has not left.
I did not say so. What I'm trying to say is that the party, New Patriotic Party, can elect to forgo that. And in our constitution, we can decide to say that, okay, you are automatically not a member if you go independent. But if we don't notify you or notify the speaker or say so, you cannot take action on behalf of our party.
Wow.
Oh, really?
Wow.
Now it says, okay, either the person leaves the party, which brought him to parliament, and he joins another party. In this case, none has joined another party, correct? Or seeks to remain in parliament as an independent member. Okay? Or H, if he was elected a member of parliament as an independent candidate and joins a political party, and that is what applies to the first deputy speaker. Is it second or first?
The second
deputy speaker.
So something
he was going for elections.
Yeah, he's independent. And
he was going for elections on the ticket of the party.
Yes.
Problems happened. Then he decided to go independent. And you declare to the whole world that he doesn't belong to your party. Correct? Right. You went to parliament and insisted that this is his position. Now he has served you. It's time for another election. You say, welcome back. So he's joining your party from being an independent, correct? Is that the case?
Yes.
So have these provisions kicked in?
So you see, Samson, my understanding, that is why we are at the right fora at the Supreme Court with their original jurisdiction of interpreting the Constitution. My understanding of this in Article 97, both G and H is saying that if Parliament, I am elected, I was sponsored by the New Patriotic Party, and I am a member of Parliament for good people of Tolong, ticket of the MPP on the 8th Parliament. So now, if I don't want to be MPP again, and I want to be independent, or I want to join NDC in the same 8th Parliament, and want to remain in this same 8th Parliament, then I'll vacate my seat. But if I have filed when to contest an election, and the notice of pool, like the Speaker said, but as of Thursday he has it, that was less than 60 days to election.
Right.
And by-elections cannot happen within that period.
Right.
They seek to represent those constituencies as independent candidates, and the other one as New Patriotic member on the 9th Parliament, not the 8th Parliament.
Thank you.
So that's my understanding.
So look at it this way.
You understand?
Look at it this way.
So that's why we are the right fora for them to give us the proper interpretation of.
Right. Interpretation happens when there's an ambiguity.
There is.
Okay, fine.
Because we are saying that the Speaker,
let's hold on. Let's hold on.
Have said that.
Last one.
By the operation of the
Let me
law,
put this to you. I want people to follow us. I want people to follow us. So you, Habib, you get elected, re-elected, which is your prayer. That's in the 9th Parliament. Thank you. In the 9th Parliament, you are coming back as MPP.
Yes.
So let's say that you do 1 year. Then after the 1 year, you announce to all of us that the next time, next election, I will contest.
That is after 3 years.
No.
If you say I do 1 year,
you don't wait until getting to the end. But maybe in your first year in Parliament, you announce and say, I don't like this MPP again. I'm unhappy with them. Next time, I'm going to contest on the ticket of another party. Okay? Or I'll contest as independent. Would the MPP fold their arms and watch you and say, you should wait until everything is over, then you come to the next Parliament, because that is when you want to be independent or join another party?
We don't have this scenario, Samson. I don't want to assume.
I'm just asking you a question.
I don't want to assume scenarios. Okay. We don't have this scenario. The members who have taken the decision to go independent, if you look at the two scenarios, unless when we exclude Fomina, the independent member, Honorable Cynthia Morrison contested the parliamentary primaries in MPP. That is about 7 months ago, and then she lost. Then Kojo Asante also contested in Suhum.
Okay.
And he also lost. And then they decided to go independent. So it is not, if they had won the primaries, I don't think that the issue of they going independent would have arisen.
Yeah,
but they feel like, okay, we lost. But we still think that the people who vote for us when we go independent. And that's why they are going independent. And they're not going independent to remain in this 8th Parliament. That's what the point that needs to be made. They are seeking. I know lawyer, doctor here know that that's the right way, that they seek to represent
I disagree
their people.
with you.
That's
and
why
I'm not being dishonest about my views.
So because you disagree, and I also disagree with what you think about Article 97(1) gene, and then as you added H.
Okay, so
that is why we are the right.
Yeah, I'm being called upon by my production to take a break before I come to Dr. Arthur Kennedy and Mame Mensa Bonsu as well. I'm thinking whether I should have Mame speak to the law before Arthur Kennedy speaks, so that he gets to appreciate a lot more, because he's no lawyer. Many people are raising all sorts of suspicions that this thing was too much of a speed. The Supreme Court, what were they in a hurry to do? Why didn't they say they should wait until the other parties have been notified? There are some who are saying their trust in the court is completely gone. There are some who are looking at the judges and saying the judges that were sort of quote-unquote picked by the CJ to sit on the matter, they are sort of aligned, and so that is how it came, and they are coming back to the issue of unanimous FC. Are these all fair from the point of view that she sees it as a lawyer and as the very good lawyer and constitutional lawyer theorist that she is, before Arthur Kennedy will join us? So be patient with us a little bit, but there's a point that is being brought to my attention by another lawyer in respect of one of the faults that Dominic Ayeni raises. And he says, I wish to bring to your attention that it is permissible to file a stay of execution without first filing a notice of appeal. Order 45, Rule 15 of CI 47. I concede that this may not apply to the matter in contention. I only seek to correct the impression that notice of appeal is a condition precedent to the filing of application for stay of execution. I also think the application should have been an application to suspend the Speaker's ruling if the order is not executable. But generally, I hold the view that the Speaker's ruling is executable in that the marshals in Parliament could enforce it by preventing the affected MPs from taking their seats in Parliament, or if they have already taken their seats, will be forced out. And finally, the problem I see with the Supreme Court's ruling is the grant of the order until the matter is determined instead of for the 10 days since the application was filed ex parte. So that's another issue many have raised, many lawyers are, arguing about, and I have a law teacher, a number of them. One of them posts on Facebook, he says, teaching law is now the most difficult thing to do. It's like we all have to learn all over again. And, ordinary people are also feeding into all of that and saying something may have gone on wrong in the court. Because the law is that if you file ex parte on the blind side of the affected party, the order that must be given must stay for only 10 days. By the 10th day, you would have brought things to their notice. So they will also come to the court to be heard, so that the court will now make a decision. But in this case, even though the application was asking for 10 days and the lawyer asked for 10 days, the Supreme Court decided that they will give them until the case is determined. So if the case has to be determined next year or whenever, Parliament literally has been injuncted. We'll be right back. You're welcome back. This is Newsfile. It's your most authoritative news analysis platform. And here on Newsfile, we put Ghana first. And my guest in the studio, you have been listening so far, Dr. Dominic Akuritinga Ayene, who is MP Bolga East and former Deputy Attorney General and Minister for Justice. Alhaji Habib Idrisu is MP Tolong and first Deputy Majority Whip. Majority Whip. On Zoom, Dr. Arthur Kennedy, physician and political activist, and also Dr. Mensa Mame Mensa Bonsu, Associate Professor and Head of Ashesi Law, Humanities and Social Sciences Department. And she's the one you are going to hear next. But before we do so, just a couple of your messages that you have sent in. Iraba Opoku Bediako says that I think this law has to be looked at by the Constitution Review Committee because looking at the time that the Speaker made the ruling, there's no way a by-election can be done. So I think we should put a time frame so that that when it's about 6 months into election, there wouldn't be the need to apply it. Oh, really? Interesting view there. Then Ernest says the lawyers of Afenyo Marking erred, and the Supreme Court also erred. At best, they should have gone for a suspension of the order, not a stay of execution. Okay, so you agree with the lawyer who sent me the message earlier. And that's a senior lawyer from an important place, but for purposes of confidentiality, I can't disclose that lawyer. So you agree with him. Ernest agrees with him and says there is nothing to stay, which is even executable in the first place. In fact, which of the processes of execution can the Speaker use to enforce whatever he said? Okay, so in law, we have processes of execution. So he's saying you can't use any of those processes of execution in law to execute the Speaker's orders. Therefore, there's no executable decision which is amenable or liable to stay. Right. Then he says, in fact, the Speaker has not even the powers of imprisonment, which is a judicial power vested only in the court. The mode of execution is well settled. It does not include the marshal walking you out of Parliament. Thanks, Ernest. Then these tweets, let me share them quickly. These tweets, this one from Promise Domevi, It says the judiciary under Nana Akufo-Addo's government, from bare certificate judgment to staying of Right Honourable Speaker's ruling, do not justify the observations of the Martyrs' Day celebration anymore. Very sad country. Carlos Vela says, in a very bad and corrupt society, integrity does not matter. Precedent don't matter. Knowing the law don't matter. Just appoint friends and allies to the right places, and whether fair or foul, they will be behind you. Man Friday says, what if the Speaker of Parliament decides to ignore the Supreme Court's ruling? What happens next? Okay, we'll wait for Tuesday because we are getting some indications that they may simply just call the bluff of the court and wait for the court to say they are citing the Speaker for contempt. And there's an argument, even including by a PhD holder who has done an article, also saying the speakers to the Parliament who has the powers of contempt, they too will cite the court for contempt. What chaos. Anam St. John says, absolutely no court should interfere with the proceedings of Parliament. Let me now go to Mame Mensa Bonsu. Thank you very much, Prof. What do you make of the arguments that are coming forth, including that there was a suit that was filed on the 15th, and there was an injunction application that was filed, and the Speaker should have waited because it's a matter of interpretation of the Constitution, and they should wait for the court to interpret before he could have done. What he did was interpretation, which is not his domain, which he shouldn't have done. And the other issues that are coming up about whether one branch of government, the Supreme Court, and another branch of government, the Parliament, there can be what is called interference. Is there an interference in the first place? Let's hear you, Mami.
Okay, Samson, there's so much to respond to here. I'm not even sure where to start. All of it is really riveting. But let me, I think I'll start with a very minor thing so we can get those out of the way quickly.
Okay.
That whether it's a ruling or information, that debate, first I'd like to explain why that matters. It's not a semantic debate. It's because if it's a ruling, there are different implications from if it's merely information. So that's why it matters. Now, let's look at the claim that it is a ruling. If I show my license, my driver's license to a cop, and he says, okay, you are validly licensed, you can drive, has he made a judicial decision? Has he made a ruling? Or has he simply applied a rule that exists? For it to be a ruling, there must be some measure of discernment that and some weighing of evidence. If you simply take evidence that to which a certain rule applies, and you apply the rule, are you making a ruling or are you simply applying the rules? I think we have to be clear on what the Speaker said he was doing. Admittedly, what he says he is doing is not determinative of what he's doing. If I say to my class that I'm issuing a deportation order to one of my international students, and what I give them is homework, it's homework. It doesn't matter that I've called it a deportation order, or I say it's an order of the Privy Council. It's homework. So it matters that we look beyond what he said. But in truth, what did he do? He received facts, and he said, based on this rule in the Constitution, these facts mean that this and that has happened. So I am informing the House that this has happened. I don't see how that makes it a ruling. And then I'm going to answer the issue of whether it's executable. I think simply because there are consequences does not make it executable. If my boss makes a decision whether that I have not earned a bonus this year, it has implications. Other departments, finance is going to take actions based on that decision. Does it make it an executable order? In the course of administering any institution, the executive is constantly making decisions based on rules and facts. Not every one of those is executable in the way in which the court operates. So I think we must be clear when we say it is executable, that it meets the standards that the CI 47 envisions when you talk about execution. Then I want to quickly respond to Honorable Habib's statement about Order 93 being the premise of the application. I think that's completely irrelevant to whether the Speaker was able to say so under Article 97. A standing order of Parliament can never oust the jurisdiction of an article. So he came under Order 93 and then raised the matter that was affected by Article 97. It is no defense to say, well, Order 93 doesn't allow that, so that's that. So that was a pick. And then I should say very quickly that if the Speaker resists the court order, our Constitution doesn't actually, contrary to what most people believe, treat all three arms as coordinate. That's what the implication of what I've argued elsewhere is the overly robust, the overly sharp teeth of our judicial review mechanism. Because in Article 2, the court can direct its order at anybody. And even in the case of the president, non-compliance is a ground for the removal, for the impeachment of the president.
High crime.
So it is a high crime. Simply in ordering that the arms in that way, the Constitution has said that it is supreme and it is enforced by the Supreme Court, and the Supreme Court therefore has supervisory jurisdiction over the other two arms. Now, in the interest of longevity and perhaps a lack of friction and stability, it is best for the court to keep that semblance of coordinate status. But let us not be deceived. They are not actually so. There's no method by which the Parliament can remove the CJ, but there's a method by which the court can remove the Speaker. And so we should be clear on that it is not a useful conflict to encourage. I think the Supreme Court has thus far, there's no instance of a high crime yet, but there are plenty of instances where someone has tried to bring a matter in a way that could have allowed the court to make such a declaration. Margaret Bamford is a quick example of that. The court has generally been quite mindful of not causing these head-on collisions, which in law it would win, but in politics it would cost the entire polity, right? So the court has generally been quite mindful to avoid the unduly upsetting the structure, and I would encourage Parliament to continue to do so this time and not cause the collision that really is not helpful to anyone, regardless of the problems with
the doctrine of the political question, right? What is it?
So it's a wonderfully American term, which I argue doesn't apply in Ghana at all. Hey. The political question doctrine is. So I say it's a wonderfully American doctrine because in the American Constitution, the Supreme Court doesn't actually have the right to review executive or legislative actions. The Supreme Court doesn't actually have a right to do so. The interpretation of the Supreme Court is not definitive in their law. It is a power that the Supreme Court explained why it ought to have and then assumed. And after 200 years of having had that power, it has been legitimated. But there have been instances, I think Gerald Ford was one of the presidents who declared that the Supreme Court has no exclusive jurisdiction to interpret the Constitution. And so where his interpretation conflicts with the Supreme Court, he has as much rights to go with as the Supreme Court has to go with the Supreme Court, right? Because of that particular lack of firm legal backing, the U.S. Supreme Court developed the doctrine of political question to avoid situations where the executive simply says, I won't do it, because they don't have anything to stand on to do anything to them if they say so. Now, if you go back to our Article 2, we have created the high crime of the Supreme Court being ignored. That means that nobody's interpretation is equal to the Supreme Court's. And nobody can say, I don't agree, I won't do it. By so doing, the Constitution has provided the Supreme Court with the grounds to look at any question of our governance, no matter what. So there is no such thing as a question that is too political for our Supreme Court to get involved in. And indeed, I think Taylor JST acknowledged this fact earlier. It works in a very specific context. It doesn't work in ours.
Right. So let me try and do this, and let's see how we are able to summarize matters at the first place for our viewers and listeners. When the issue is raised that this is the interpretive jurisdiction of the Supreme Court, and therefore the Speaker ought not have done what he did, but he had to wait. he ought to have waited for the court. Your point is that that is not accurate?
As you noted earlier, the Supreme Court has said that it will not, that court, that where there is no ambiguity on the face of the provision, interpretation is not required. It is simply application. And if you are a body vested with the duty to apply it. So there's no, if you say that there's a question of fact here, that's a different thing from a question of law and a question of constitutional interpretation. Even a question of law is not necessarily a constitutional interpretation matter.
Right.
Just because you don't agree with me doesn't mean an interpretation matter has come up.
Thank you. Christopher Nyanivi, Dr. Christopher Nyanivi, writes and says, demystifying the exclusive jurisdiction to interpret the Constitution. Then he just wrote this on the back of all of this discussion. I quote a portion from what he said. He said, I do not share that view. He's talking about the view that says the court must rule before. The Constitution creates 3 co-equal branches of government, with each assigned specific functions under the Constitution. In performing their functions, they are each supposed to apply the provisions of the Constitution that are relevant to their mandate. This necessarily involves having to decide what, in their opinion, the particular provisions mean and what they require of them in every instance of executing their mandate. It follows that in performing their day-to-day functions, the political branches have to interpret the Constitution. Indeed, various officers within the judiciary, including the Chief Justice, when acting in their administrative roles, including at the Judicial Council, also interpret and apply provisions of the Constitution in the execution of those functions. A fetish must therefore not be made of the idea of interpreting the Constitution, and the impression should not be wrongly created that the Supreme Court is an oracle that must be consulted every time a person or authority has to make a decision that has constitutional implications. This is because the court is a judicial body that decides constitutional disputes as and when they arise, and its jurisdiction has been properly invoked. It is not a constitutional advisory council mandated to give legal advice or opinions on matters before any branch or agency of government before they take their decisions. Now, I mean, my issue that I come to you with is also still on the political question doctrine. Joseph Kweku Asamoah, Dr. Joseph Kweku Asamoah writes an article on this issue and faults the Supreme Court. I quote this to you and check if you agree. The Speaker of Parliament's decision to declare the seats of the MPs vacant is a lawful exercise of power derived from both the 1992 Constitution and the Standing Orders of Parliament. The Speaker's authority to declare seats vacant under Article 97 is not subject to judicial review. Please note that, not subject to judicial review, especially since it pertains to parliamentary discipline and internal governance. The judiciary has no constitutional basis to question the Speaker's ruling, as it concerns a parliamentary procedure over which Parliament has exclusive jurisdiction. You agree?
Absolutely not. Absolutely not. I agree in part with Chris. I disagree with his use of interpreting as a daily exercise. I think what they do as a daily exercise is apply. And as long as they apply, that's fine. To the extent that to apply, you must understand, and to understand, you must have exercised some version of interpretation. He is right. But it's a very minimal level because it is what the provision on its face said. The Supreme Court's interpretive power is to say where we are not clear what this thing means, or where we're not clear whether an act falls within a specific clause's meaning, then there's interpretation that must be done. Samson, can you hear me?
We can hear you clearly.
Yeah. Excellent. Okay. So application is done on the daily by everybody, to be honest, by everybody. But interpretation is done by the Supreme Court.
Okay.
If there's a dispute, the Supreme Court decides it. Now, in response to Kweku, there's nothing in our Constitution that is not subject to judicial review. Go and read Article 2 word for word. There is absolutely nothing that is not subject to judicial review. What Parliament is immune from is judicial instruction about its daily affairs in the way that it conducts them in the application methodology, right? So the court cannot tell Parliament today, talk about this, or tomorrow, do that. And in J.H. Mensah, the court says it has the right to see that the constitutional provision has been implemented. Where the constitutional provision gives Parliament discretion, its job is to make sure that Parliament is exercising the discretion, and it's exercising the discretion in line with 296. It cannot question the outcomes, but it can question that this methodology can lead to that outcome. So do not be deceived about
Is it in J.H. Mensah? Is this in J.H. Mensah that the court said Parliament is a master of its own rules, and what it does is a closed book? What does that mean?
It means that Parliament decides how it will run itself. To the extent that it is not doing anything the Constitution has not said it cannot do, the court cannot go into Parliament's house and say, you know what, the NDC should sit on this side, MPP should sit on that side because we think it gives greater clarity. Or that, your standing orders should be published in green. The court doesn't have the authority to tell Parliament how to do its work. It has the authority to tell Parliament when Parliament is not doing its work constitutionally. There's a big difference. One is a journey of constant preemptive instruction, and the other is a simple review as and when there is a question about compliance. To that extent, there is nothing that is not judicially reviewable in our Constitution.
All right. Now,
Parliament should keep that in mind. And someone said something about Parliament citing the Supreme Court for contempt.
Yes,
Parliament cannot do that. Joseph
Kweku Asamoah said so, because it says Parliament has powers of contempt, and the courts also have powers of contempt. They are the only two institutions that have powers of contempt. So he says Parliament can cite the court if the court attempts to cite Parliament for contempt.
Absolutely not. Parliament is independent and subject to the procedural supervisory jurisdiction of the court. The court is not subject to the procedural supervisory jurisdiction of Parliament. The court cannot tell Parliament, the idea of waiting for the courts to declare to interpret everything before Parliament ever acts includes that for Parliament to be able to discuss any piece of legislation, it must go first to the Supreme Court to ask if they have the rights to discuss this kind of legislation.
Okay.
Right? That's not how it works.
Right.
They can go ahead, and if they are wrong, then we review it.
I'll come to you.
But to think that Parliament can cite the Supreme Court is to completely misunderstand the power structure of our Constitution.
So if the members of the Supreme Court are acting in the administrative function or acting not as in their judicial, function. In fact, the Constitution says you cannot hold them liable for their judicial functions. But if they are acting in a non-judicial manner, they could, like all ordinary citizens, be liable to Parliament's contempt, correct?
If they were acting in their personal capacities in administrative positions, Parliament's contempt powers are contempt of itself, and generally apply to non-attendance, non-compliance with its orders. To the extent that Parliament can order a Supreme Court judge I can't even imagine the situation where the Supreme Court judge would be acting in a maybe the Supreme Court judge will say administrator of a school. But they're not equal powers, let me put it that way. So Parliament's contempt powers are supposed to help it extract information to do its work. And the Supreme Court's contempt powers are supposed to help it preserve the order of the state. So I wouldn't think
the parliamentarians will argue that their contempt powers is also for them to preserve the order of what they do, and that's how come they have invited members of the public who have made certain comments about the things they have done to appear before them. And I'm bringing this up also because Sam George just held a press conference and issued a statement in which he said that a judge, in responding to a press statement a press conference, after a demonstration that he led, the judge told some lies and those lies sort of bring Parliament into disrepute. And on that account, he was going to have the judge, as it were, ordered to appear before Parliament's Privileges Committee.
Samson, unfortunately, I can't hear you. I think my internet has dipped.
Okay, let's try again. I'll move on to something else. Can you hear me? Okay, I understand, Mami, we need her. We need her. Bright mind. The best, constitutional theories that you can have. The elucidations that she gives. You just will love it. And I'm just going to go to one other issue with her, where some of the lawyers all over on social media are asking questions about what happened to Tufor versus Attorney General, where the court said, that's the Supreme Court said, there is a long line of authorities which establishes two important principles governing the relationship that subsist or should exist between Parliament and the courts. A, that the court can call in question a decision of Parliament, but that the courts cannot seek to extend their writs into what happens in Parliament. And B, that the law and custom of Parliament is a distinct body of law, and as a constitutional expert, as constitutional experts do put it, unknown to the courts, and therefore the courts take judicial notice of what has happened in Parliament. The courts do not and cannot inquire into how Parliament went about its business. Okay, she says something about that, and also actually emphasize another point, which these lawyers may be invited to the case of Justice Abdullahi versus Attorney General 2022, where the court said neither Parliament as an institution, nor its members, officers, orders, practices, conventions, or procedures can be said to be independent of and or exempt from the limitations imposed by the Constitution. So, Mami, what's your expectation after the court issues the orders it has issued to Parliament in the stay of execution of the decision of the Speaker?
You got me there, Samson, because I don't actually think that first of all, as I said, I don't really think that there's an order to which a stay can apply, because I think it's not an executable order. I also not sure why that's an ex parte application. I think on the basis of the audi alteram partem rule that the majority was invoking, that they should have, in full respect of that rule, chosen to give notice to the Speaker, I think. When a person who has a duty exercises their duty and you disagree with it, I think you go for a supervisory order. You apply for a certiorari or mandamus as applicable, and that's on notice. So I'm a little stumped what the next step should be, to be honest. And again, the fact that the order is until the matter is determined, as opposed to the 10 days that ex parte applications are supposed to get. Perhaps the minority would like to request the court to review that order and bring it in compliance with the
I get it that your advice to Parliament is that they should not say because there was no executable order and this could not have happened ex parte and so on and so forth, and that the grants instead of for 10 days has been given until it's turned into an interlocutory injunction, so to speak. They should disobey it. They should rather go to the same court and seek to set it aside before they proceed with what they have to do. Ex parte affoda says that even if an order or a judgment is unlawful, is wrong, you don't disobey it, correct?
Yes, I think the method of, the whole point in a judicial system is to create some finality to actions. So if everybody is to take their own interpretation as correct and disregard the courts, we'll be back in a state of nature, to be honest. And so that one of the key reasons why separation of powers has been proposed as a useful way to run a country is the principle of institutional settlement, which is a principle about finality, right? So Waldron argues that it's not really that this is the institution that will get the answer right all the time, or even that this particular answer is right. It is that this particular answer is final and we can respond to that. So we have a methodology for speaking to our court when we think our court is wrong. That's the methodology you adopt. You don't then say, well, I think they're wrong, so I won't do it. Because when you do that, what we're saying is that every time there's a decision, people should judge whether that decision ought to be obeyed or not. In which case, what's the point in the court? Why don't we just let the people figure it out in the first place and then decide what they will do and fight if they're wrong? If they can't agree, then they should fight, and then the strongest should win. That's the state of affairs that we chose to leave when we decided to set up a constitutional government. So if it is wrong, use the methodology to correct it.
The question some lawyers are asking...
Parliament should not be an institution that sets the example to the citizenry about how to treat the Supreme Court.
The question that some lawyers are asking on the back of this is this. If this had happened in the High Court, maybe the affected parties will say, now we move up to maybe Court of Appeal or the Supreme Court. The Supreme Court is the court that has done this. How do they go about it? Because normally, these things, they are sort of an action in appeal. Stay of execution, often, that's what they are. There's actually this authority that requires that there must be an appeal before there's a stay of execution, even though that does not accord with Order 45, Rule 15, that was pointed to me by another senior lawyer. So I needed Mami on that. Okay. Mami says, if you do anything at all, don't go to Parliament on Tuesday and cause chaos. Don't go to Parliament and disobey the court. Rather take legal steps. And my question to her now is, some lawyers are raising this. How else do you go up? Because...
Well, something is, I think she's right in respect of how we proceed. Habib had pointed out the distinction between politics, the conduct of politics in the House and the settlement of legal matters, right? In settling this legal matter, the best will be for Mr. Speaker's lawyers to apply to set aside, to vacate the order of stay. Okay.
This was unanimous, so.
Yes, why not? But if legal argument is brought to the attention of the court that the court was wrong, that it erred in granting the stay, I think that the court, should be minded to reverse itself.
So it is possible that by Monday when we wake up, the lawyers for the Speaker would have filed a process to vacate this order. And they would have also filed a stay of execution of the
Supreme Court order.
And then the status quo ante will remain. That the Speaker's orders will be
well, that is what I expect. Okay, and I actually, talked with Mr. Speaker's lawyer, not today, but I think yesterday in the afternoon. At the time that I was speaking to him, he hadn't had the full complement of even the writ and the statement of case as well as the ruling. But I'm sure by now he would have them and he will work over the weekend to be able to file those things.
Interesting.
But something I just wanted to, Mami said something about methodology as well as outcomes. And basically what I understood her to be saying was that the court can question the methodology, but not the outcome. I think it's rather the reverse. It is the court does not question how Parliament conducts its business.
But
that is the methodology. But after it is done, the outcome can be questioned.
That's right.
If it constitutes an act or an omission that contravenes the Constitution.
Right.
Secondly, I also wanted to point her to Article 35 of the Constitution on directive principles of state policy, where it is stated, and I think that for the benefit of your viewers, I know we don't have a lot of time,
right?
But it says that Article 35(1), it says, the directive principles of state policy contained in this chapter shall guide all citizens, Parliament, the President, the Judiciary, Council of State, the Cabinet, political parties, and other bodies and persons in applying or interpreting this Constitution. All right.
Or any other law.
Yes.
In taking and implementing any policy decision for the establishment of a just and free society.
So I agree with her that there is some level of, interpretation of the Constitution at the level of the administrative state.
Right.
But when there is ambiguity and there is a dispute as to the meaning and the implications of that provision, it is the Supreme Court that has the final word.
That's right.
So the fact that it has the final word doesn't mean that it has exclusive power to interpret the Constitution. We all interpret and implement the Constitution.
And another senior is pointing out to me that we should not give the impression that it's a general situation that the CJ cannot be subject to Parliament. And he's pointing to maybe Public Accounts Committee as things.
Yes.
We can
hold her in her administrative capacity. All right. She can be held before
Thank you. Let me go to Dr. Arthur Kennedy. Yes, Doc. Now, having listened to the parties and the constitutional lawyer, what are your views about what is going on? I can foresee a tumultuous Tuesday. I will not say a chaotic Tuesday. I can foresee legal battles one after the other, because it looks like you can predict that by Monday, the Speaker's lawyers would have filed a process to vacate this order, and then on top of it, they would have also filed a process to stay execution of what the court has given, which will mean they can go ahead on Tuesday if a decision is not made immediately, where the MPP will be minority and the NDC will be majority. Let's hear you, sir.
Yeah, I feel like the teenage bride at her wedding in the midst of all these legal luminaries. I am truly at sea, but I realize that the law is too important to just leave to the lawyers.
Correct.
The constitutional lawyer was brilliant. I think someday she will be a judge. But respectfully, as far as I want to make a couple of comments on what she said before I go to my main submission. As far as the US is concerned, there is actually no competition between, say, the Supreme Court and other branches of government as to who determines what the Constitution says. That has been the case since Marbury versus Madison. And if you look at recent instances about Nixon's tapes, about, for example, even recently Biden's immunization policies that the Supreme Court knocked back, and last year's Chevron decision, in which the court said Parliament, the House of Representatives of Congress cannot grant the powers of interpretation it has granted to administrative bodies. It is very clear to everybody here that the Supreme Court sits unchallenged as the arbiter of what the Constitution ought to say. To go to Ghana, she seems also to assign the same overwhelming powers to our Supreme Court or our judiciary. And actually, some of the seniors, they have pointed out that the relationship between Parliament and the Supreme Court is not one of superior to subordinate, that they have different functions. And as it was helpfully pointed out, there are actually instances in which Parliament too can question some of the things that the court does. Actually, even in the case that he cited about, say, the Speaker being subject to impeachment and others, she didn't add that that impeachment must be carried out by Parliament. So in effect, the court cannot impeach the Speaker on its own. And if indeed it triggered an impeachment of the Speaker and Parliament refused to vote him out, he will still maintain his position. Others have helpfully added, of course, the fact that, for example, Parliament, when it receives the audited accounts of the Supreme Court, can call members of the Supreme Court to come and answer for potential malfeasance or misappropriation of funds. And there are reports that, for example, that was what we were on the verge of witnessing when Domilovo was removed. But that one is another case. As far as this is concerned, let me take it at different levels. The first thing is the speakers and their rulings. I believe that taking everything into account, maybe Professor Michael Quay and Speaker Babin may have been a little too political in the rulings that they both respectfully made. As for Professor Quay's contention that it is a political party that must trigger the declaration of vacancies, it will lead to all kinds of inconsistencies. And I actually think that that view, that's Professor Quay's immense intellect at the service. He erred in his ruling and he should stop defending the indefensible. I think that particularly in the ruling, and I think he says it's information, but it's a ruling by Speaker Babin, if, for example, this parliament has, say, a year left or 2 years left, and they declare those vacancies, you could have gone to by-elections, and those who could contest again will contest, and they will have representation. So that is actually neither here nor there. But then let me go to the conduct of the Supreme Court. All these things are seen in context. And I actually like the quotations you read because I had it here and I was going to read it in Tofor versus Attorney General. And you read it very well about when it says it brings us to the question of how far the courts can question what under our Constitution has been done in and by Parliament. And it goes on to cite the two situations that you did. I think that even though there is a Constitution and the law, they ought to be traditions. Our branches of government have to work together. And I fear, as a patriotic Ghanaian, that in too many occasions, like the Domilovo case, the LGBTQ case, and in this current case, that our Supreme Court appears now to be doing more politics than law. I remember that Justice Scalia of the United States Supreme Court gave a talk in which he said he went to South America and he was talking to a judge, and the judge said, "How do you do it?" And he said, "Do what?" He said, "Why is it that you have no army, but all the branches of government respect your rulings?" Because elsewhere in the world, what the judiciary says does not always go. And for Ghana's judiciary and Supreme Court to continue to maintain their standing and the respect that they enjoy, they ought to be mindful of where they are in politics. It is strange, for example, that Domilovo's case took as long as it took. It is strange that the LGBT case brutally truncated the lawmaking process that has been clearly set out and has now, brakes have been put on it. And all of a sudden, this case, we managed to empanel a group of Supreme Court judges, and within a day, a ruling had been made. When these things keep happening again and again, there is the perception that our judiciary is biased and too political, as Kandapa and former President Mahama did say. I fear that sooner or later, we are going to get into the realm where every new government will insist on having its own Supreme Court and its own Electoral Commission because it does not trust the previous one.
Dr. Takere, just a second. I should say, though, that as a practitioner, in the ordinary things, I could file such applications on the same day and be heard on the same day. They filed this around 10-something, and by 11 it was being heard. Albeit Supreme Court, a full bench, a 5-member bench. We say they should be speedy about things. This Chief Justice has laid out her vision of the leading justice. A part of it is speed. So sometimes we may have suspicions that are unfounded.
What happened to the LGBT case? And by the way, let me take you up on the speediness. if I was the Chief Justice and mindful of speed, and I think speed is of essence here, he should have asked both sides to show up on Monday in court with a panel ready to debate the issue. I can tell you that in 2 hours, the lawyers for both sides could have debated all the issues and they could have issued a ruling that night that would have been substantive. Even though this is only a stay of the Speaker's ruling, in effect, it is a ruling because if you do nothing, it has the practical effect of vindicating one side and leaving the other side. And given how long they took on the Domilovo case, we cannot take it for granted that the justice here will be done speedily.
Okay, I've heard you on that. You can proceed.
Okay, so my point is that as a nation, we need to make sure that we put in the guardrails. I think that this judiciary, and particularly this Supreme Court, is too eager to stick its nose in political affairs and to stick it in consistently in a manner that seems to favor one side. It is dangerous to the stability of our political polity. And I think that this underlines the need for sweeping judicial reforms, where it brings up my point about Mami Mensah Bonsu, that Parliament has...
But that statement, is it a fair one to make? Because those people who have gone to court and gotten this with the speed of light, the affected parties could also initiate counter processes and potentially could also be heard at the same time. So that will...
Yeah, they should, but looking at Domilovo, looking at the LGBT case and looking at this one, where do you think the court will finally come down? So let me just go on. I'm just saying that the judicial reform we need to do is that we need to clarify the appellate process. We need to clarify how panels are chosen. I do not think the choosing of panels should be left entirely to the discretion of the Chief Justice, and we should put a cap on the number of Supreme Court judges, because it is dangerous for one president to have an unlimited power to just keep naming Supreme Court justices on a whim. That is dangerous to the stability of our republic.
The president has not been naming justices on the whim. As the vacancies become available, he is advised by the institutions that are supposed to, and then he makes the nominations for appointments. That's all he's done, correct?
How many judges do we have, and how many are they thinking of bringing in more? I'm just saying there ought to be a cap on the number of judges we have.
The court presently may be full of judges appointed by Akufo-Addo, but he didn't just get up to appoint them because others had retired and left, and he needed to fill the vacancies.
Yes, and now he can even add more new ones because there's no cap on the number of Supreme Court judges. And that is not good. That's my point.
Okay. Doc, okay, proceed. I interrupted you.
That's all right. I always like having back and forth with you. But my point is that the stability of our institutions require deference to Parliament and how it does its work. That is not to say that Parliament can do whatever it likes. But I'm just saying that the situation we have now is undermining the confidence of the public in our judiciary. And that is not good for anybody, including the judiciary itself. I think that this particular case has not been handled well, and that hopefully next week, when the Speaker's lawyers go before the Supreme Court, they will have had time to reflect over this, and they will make a ruling that will restore the public's confidence in their impartiality. As things stand now, I do not think most of the public believe that this Supreme Court is impartial.
Okay, Doc, hold on for me. I'll take a quick break and return. Or before that, let Mami make this point. She wants to make one particular point about the matter where Habib suggests that even though their constitution says that once you move away, you lose your membership, it is up to them to decide whether you have lost your membership or not before a speaker can act. Hello, Mami.
Hello, Thompson.
Yes.
Sorry about my internet today.
Right.
I wanted to address that issue because I found it very troubling. Honorable Habib does not understand the Constitution then, because the whole point in the Constitution is to set out these rules that everybody under it must obey. So if the Constitution creates a National Council and says the National Council members have executive authority, the National Council members may not then take the benefit of the Constitution creating them to override the Constitution. If the Constitution says automatic forfeiture, unless they can find a clause in their Constitution that says unless National Council wishes to make another decision, National Council has no power so to do. You can't be in court saying that the Speaker has acted ultra-virus and hold the position that your National Council can do whatever it likes and can go contrary to the Constitution that creates a National Council at all. So, Honorable Habib, please, they are no longer members of your party. That's what your Constitution says. It doesn't really matter how the National Executive
All right,
Council
we'll take
feels
a quick
about
break. We'll be right back. All right, so we can only take some wrapping up comments. Let me go back to Dominic. Maybe, can we even do 2 minutes each? It doesn't look like we have. So let's go on.
Well,
in the public domain, there's something you and I as lawyers can do. The judiciary is all we have. It's the last institution that must not go through the bastardization that destroys, the institution. People are talking about SAL, that you didn't do SAL this way, that even the Asin North MP was injuncted, not to go to Parliament. How can you now say that these four people, they have been deprived being in Parliament? All these things, every case is unique on its own. People should not be making these permutations I say think the court is doing politics, correct?
I think for want of time, Dr. Atta Kennedy, made a point where he said all these instances, deepens the perception that the court is not being fair-handed in dealing with people who appear before them. Because if you are talking about deprivation of representation, at the time that the court issued an injunction against Judicial, was it not mindful of the fact that the people of Asin North were going to be deprived of representation? And elections law is, the principle of elections law is that, you, as much as possible, you should not deprive the people of representation through restraining orders from the judiciary until such a time that the substantive matter, is determined. All right. The same can be said of the people of SAL, right? For 4 years now, they have no representation, and they've been going up and down the judicial, ladder from the High Court all the way to the Supreme Court. And the Supreme Court is very much aware of this. So for me, something, for the lack of time, I would say that if the court does not put its house in order, the perception that it is doing the bidding of the ruling government will deepen in this country, and that is not good for trust in the judiciary and its neutrality.
Thank you.
Yes, I think something we need to
people
respect.
People are saying you guys are doing double speak. You can't. Your trust, your integrity levels are questionable, because like those who referring to the Asin North issue, you guys were happy and said yes, it ought to be done. Now this one, you are happy about it. You are happy about it. That one,
something the Asin North issue and what the Supreme Court did was different entirely. There was a judgment from the High Court before the Supreme Court did the order. But the same court freed the minority leader, Atu Forsen, who were all celebrating. But now that the court have taken a different this, and then we are celebrating. When the Speaker of Parliament read his ruling, then you were jubilating. When the Supreme Court brought and made an order with that, then we are having a problem. The most important thing is that the whole thing is being restored. There is going to be calm in Parliament. We are colleagues. We are friends.
Are you sure about that?
I'm very positive about it, because we have built consensus in this Parliament than any other Parliament due to the numbers. So we will definitely sit down. We will respect the decision of the court. When the Speaker did his ruling in many, many occasions, we have respected it. When the court brought their rulings in many occasions, we respect it. So on Tuesday, as people are anticipating that there's going to be problem, the majority side, we are very well prepared of anything that will properly, and will protect the Constitution.
Thank you very much. This show is brought to you by Candace sponsorship of Bank of Africa, strong as a group and close as a partner, MTN everywhere you go. HSC University, educating ethical and entrepreneurial leaders for Africa. Robert & Sons Optical Services, your comprehensive eye care service provider for 33 plus years. My Way Insurance, dial *165# on MTN to join My Way today. DPS International, where every child shines. Flamingo Paint, simply superior. Syntex Tanks is strong, it's tough. Activa International Insurance, our clients, our passion. Mami Mensa Bonsu, in some 30 seconds, I'm sorry, Mami Mensa Bonsu and Dr. Mami Mensa Bonsu and Dr. Arthur Kennedy, we are unable to revert to you.